Good morning, everyone. I welcome you back on our channel. My name is AYUSH Kumar Singh. I am from FI University, Dehradun, currently pursuing my legal internship from LEXIS and Company. Today we are going to start the topic registration of motor vehicle under Motor Vehicle Act 1988. So, why there is need of registration? According to Section 39 of Motor Vehicle Act, every person who owns a vehicle or drive any motor vehicle or either permit the vehicle to drive in and either on public place or any other places should be registered under this act with proper administrative certificate of registration, which should be displayed in a prescribed manner. Now, registration where to be made? Under section 40 of the act, in the state, any registering authority in whose jurisdiction the owner of the motor vehicle has the residence or the business can register his or her motor vehicle. Now, what's the procedure for registration of a motor vehicle? Basically, section 41 deals with it. For the registration, the owner or on the behalf of the owner of the motor vehicle, there should be fulfillment of the document, particulars and fees and information within the period provided and prescribed by the Government of India. Even in the case of joint ownership, a motor vehicle registration will be made by one of them, and such application will be deemed to be the owner of the motor vehicle according to the act. Now, certificate will be issued within the registration authority on the name of the owner and information as such as the type of vehicle and the distinguishing mark. The distinguishing mark is also known as registration mark. For example, we all have seen the BR mark for Bihar, JH mark for Jharkhand, DL mark for Delhi, and etc. So, it is the duty of registration authority to enter the particulars of the certificate in a register in such a form and manner prescribed by central government. According to section 41 clause 7, the validity of the registration certificate of a motor vehicle other than a transport vehicle, it should be noted that it is just for a motor vehicle and not for the transport vehicle, is so the validity is for 15 years from the date of issue of the certificate. After the expiration of this 15 years, the certificate can be reissued or renewed on according to section 41 clause 10. The renewed certificate is valid for 5 years, and in case if the owner fails to renew the certificate in the prescribed time, then there is an extra fees for that, and that fees cannot be extended beyond rupees 100. The fees of registration and extra fee in case of failure of renewal is also a subject of state government. So it may be prescribed a different amount in a different state. Now, in case we lose our certificate or even the renewed certificate, then there is a provision of duplicate certificate. The duplicate certificate is issued by the registration authority in such a form containing such particulars and information along with such fees may be prescribed by the central government. Now, there are some special registrations for the diplomatic officers and council officers. Now, within the meaning of diplomatic and council officers is a person acknowledged by the Government of India. In case of issuing certificate of registration of motor vehicle of a diplomatic officer under the Government of India is according to section 42. The certificate of registration are to be sent to the owner of the vehicle and the special registration mark so that it could be identical to whose vehicle it is to be assigned for such vehicles. Now, let's know about the temporary registration. Temporary registration is defined in section 43 of the Act. If the registration authority issued a temporary registration as per section 3 of the Act, section 43 of the Act, the validity of this registration is for 1 month and it's not renewable. It should be noted that it's not renewable. But if in the case the chassis of a vehicle is not attached with the body in that said period of time and is detained in the workshop, then the authority on its discretion can extend it, but it's totally on the discretion of the authority. Now, according to section 44 of the Motor Vehicle Act, it is necessary to present the vehicle to the authority, or the authority shall confirm that the particulars in the application are truly written or conveyed to the authority. Now, on what grounds or on what basis there could be refusal of registration? So, Section 45 of the Act defines says that if the registration authority of a motor vehicle has reason to believe that either the motor vehicle is stolen or there is any mechanical defect or the information provided by the owner for the registration is not correct, then the authority has the power to refuse the certificate. So here's the end of the topic. I hope you like the video informative. So like, share and subscribe. Thank you.